Well, let's start a bit of an intro. Helen, great to be able to talk to you again. So I'll introduce you if I may. So those of you that don't know me, then I'm Nigel Job, and I'm the chair of the BIVDA HR Working Party, also now known, I think, as the HR and Leadership Working Party. Also, I'm the CEO of Remtec Talent Management. So we offer HR consulting services and also a search. We're also a search business for medium to senior level recruiting. And then delighted to have Helen here with me today. Taylor Wessing, she's an employment partner at Taylor Wessing, who are also members of BIVDA, I believe, aren't you, Helen?
Yes, absolutely. Yeah.
So Helen has an interaction with the life science community. Is it largely life sciences you work with, or is that a part of your area?
It's not solely, but I would say it's a very large part of my practice. So
Yeah.
we work with, very large established life science companies right through to the sort of tiny, a PhD from Cambridge or Oxford
Mm.
or another eminent university who wants to start up in the sector. So we have some very sort of, and then lots of clients in between as well who are a lot more established on their journey. So yeah, I love working with the sector. I find it really, really interesting. I think lots of challenges, but great. It's fascinating. It's such a fascinating topic, isn't
Yeah,
it?
and it is, and huge admiration for our clients across the piece that
Absolutely.
we work with in terms of, their real passion for what they do and the contribution they make to
Yeah.
society. So obviously everyone here who's seen what this is advertised as. So we're going to be looking at really four main areas of what we anticipate to be really areas of interest in terms of changes, adjustments, etc. And what Helen and I want to give you is an overview of what you might expect, and then also what potentially you can do to either take advantage of these changes, but more particularly probably mitigate against any particular challenges that will come up as a result, because change is one of those things that we can be certain of, and obviously we've got a new government, and there are a number of changes they're bringing in. I don't know whether you want to give the little disclaimer bit here, Helen, just in terms of what people should take from this, if that's possible, please.
Yeah, absolutely, Nigel. I mean, obviously, as with always, we're not clearly we can't give specific advice today, because we're not advising on a specific set of circumstances or facts or what's absolutely going to be right for you in your business. But what I think the plan for today is to have a really useful discussion that you can all take away some ideas and thoughts as part of your planning for what's been billed as, I think, the largest or the most significant changes to the employment regime for a generation. Certainly, that's the way that the
Mm.
Labour government are viewing this. So, and there's been such a lot of interest across the media and across businesses. And I know from the work I'm doing, we're getting so many questions coming through. So I thought it'd be really useful to have a chat with Nigel just to go through some thoughts that in particular that I think will be interesting for those of you working in the sector. And the other thing we should say is also please do add questions. If you do have questions or thoughts, we'll try and if we can answer them today, but if not, we'll come back to you following the event too, which would be great.
Yeah, and it's and I definitely echo that as well. Obviously, Helen and I coming at from a slightly different but complementary
Yeah.
perspective, I would say. Similarly with us, just to do the blatant plug, obviously, if you have needs either to assess your kind of HR strategies going into the future, then that's something we'd be delighted to talk to you. And equally, I'm sure, Helen, from your perspective, Taylor Wessing would also be pleased to talk about the legal aspects of the employment side of things as well as the other services that you offer. So just to get straight down to it, then we've got the four basic areas we're going to try and cover in this sort of relatively short space of time. We've got the proposal for day one rights. We've got flexible working. we've got collective union rights, and we've got duty to prevent sexual harassment. So we're going to try and address each of those in a small way. I think, as we've just already hinted, the thing to be is to think about this from a point of view of being prepared. But Helen, maybe we can kick off. Could you sort of explain? I mean, I think everyone's got a reasonable idea of what this is, but day one rights, what does it mean? What are the implications? What's the changes from where we are today?
Thanks, Nigel. Yeah, well, I think the key takeaway is that there's really sort of two areas that the government's focused on. They're obviously they're focused on giving employees better protection and better rights. So obviously the key focus has been most of the publicity has been around the removal of the 2 year period for an employee to be able to bring a claim from fair dismissal, and reducing that down to an immediate day one right. But the other piece, which perhaps hasn't gained so much attention, but also is going to be important for businesses, is the introduction of various rights that will now start from day one rather than a longer period. So I'm just going to very quickly summarize those rights just so that they don't get forgotten
Can I
before.
just sort of, sorry if this is really
Yeah.
statement of the obvious here, but the 2 year thing is essentially that unless it's discriminatory, an employer at the moment can dismiss somebody without giving any particular reason for the dismissal up to 2 years after they've started. That's correct, isn't that?
Absolutely, yeah.
Yeah.
I mean, there are certain circumstances where employees can make a claim for what's called automatically unfair dismissal from day
Mm,
one. So if they were dismissed because of, say, a whistleblowing disclosure,
right. Yeah.
or because they're pregnant.
Mm,
But you're right, the normal rule has been for sort of issues, say, poor performance or redundancy or misconduct, within that sort of 2 year window, you can safely dismiss for one of those reasons, one of and avoid a claim for unfair dismissal. And so it's been, and I think that's something that we've all worked to. It's been around for sort of the last 14 years. For a lot of people, that's the regime that they've only ever really worked in.
mm,
And they can't remember working in a different environment. So that's going to be a massive change. Just very quickly, though, to summarize the family friendly areas that are changing, the changes are, fathers will be able to take paternity leave from day one now. There's the entitlement to unpaid parental leave. So that's if you need to take off time urgently to care for a child. At the moment, that applies from 1 year of service. It's going to reduce to day one. Bereavement leave is a new right that's going to come in from day one. And we're waiting to see the details on that. And statutory sick pay is also going to apply from day one. And interestingly, I would say out of all of those changes, they're all going to impact the costs of employing staff. And I know that's going to be an impact for some of our smaller life
mm,
sciences clients, some of the sort of more SME businesses. A lot of the people are very worried about the introduction of statutory sick pay from day one, because even though it's not a huge amount of money, I think the current amount that people can claim is it's only about £116 a week. So, but
mm,
there's been a lot of press about that, and the impact on businesses and the worry that people will sort of perhaps feel more comfortable going off sick than
mm,
they have been previously. So that's going to be interesting to see how that plays out. But I think, as you rightly focused on, Nigel, the really big change is going to be to unfair dismissal. And the reality is, as we've been saying, most of us haven't really worked in an environment where there's been a shorter period. Prior to the sort of Conservative governments, the old regime that was introduced by Tony Blair with the Labour regime was down to a year. But we've
mm.
certainly never had a regime where people can claim unfair dismissal literally from day
From day one.
one.
Yeah,
So it's going
except
to
by
be
discriminate for discrimination reasons.
exactly,
Yeah, yeah.
yeah, and so that's a really big, really huge change. And I think obviously there's been a lot of debate, as we understand, in the
Mm,
cabinet about this, but the proposal, which is a bit of a sop, I suppose, to some of the people that are concerned about the impact for business, is that there will be what in effect a statutory probationary period of it's not yet completely final, but it looks if it's going to be 9 months.
Mm.
We understand that sort of Angela Rayner and others were pushing for a much shorter period, so 3 months. So it could still reduce, but I think it's likely that it will be 9.
And I
Um,
know I'm asking you to speculate a little bit because obviously this isn't in law yet. This is, and that's important to actually state that, of course, that this is not. I don't know. Does this go through as a primary legislation or a piece of statutory instrument? I'm not quite sure. Either way, it's probably going to come in, isn't it? I think we can probably assume that.
yeah.
But asking you to speculate a little bit, that that statutory probationary period,
Mm.
does that effectively mean, as you understand it, are they saying, well, for the first 9 months, it's pretty much the same as it is at the moment, so therefore you could get rid of somebody without any specific reason in that first 9 months for non-performance or something like that?
Well, as we understand it, the government is planning on introducing there will still be a process that you have to follow in that 9 month period. So it won't be, so the current position is that if you wanted to, you could, most people don't do this, but you
Mm,
could sort of really be very relaxed about the process that you followed. You certainly wouldn't need to follow through the ACAS
mm,
disciplinary
mm,
process at the moment. What the government's talking about doing is it's introducing a sort of a fair process that people are going to have to follow. Um, there is some speculation. I don't know, for those of you, some of you may remember the old regime where a statutory disciplinary and grievance waiver, where there was a sort of a statutory mandatory process that had to be followed when dismissing staff, and that was soon abandoned because it was a procedural nightmare and employers hated it, and there was just a
mm,
huge amount of claims. So I think there is a bit of a concern about how sort of involved this statutory process will be.
mm,
But it's going to actually be although you've got the ability to dismiss someone in that 9 month period, you will only be able to sort of safely do it if you
if you
follow
follow
this
the process.
statutory
Yeah.
process, and we don't yet know what that's going to look like. So that's a big issue that's yet to be determined. So I think that's interesting.
So I think that the message really is kind of be prepared, isn't it?
Yeah.
And be prepared for the changes that are coming. What do you think senior leaders should be thinking about to ensure that they're ready for this? I mean, we've got, I don't know how long before that it will be actually in law. I assume, well, it's going to be within this parliament, isn't it? But it's going to probably
Yeah.
be maybe a year, I guess. What
Well,
should they be doing to
yeah.
prepare themselves?
I mean, in terms of timing, actually, the government have said that this will be implemented by autumn of 2026.
Okay, so
So,
yeah,
so they've
so
been
it's
very
just,
clear about that. That was one of the only, out of
mm,
all of the employment rights bills changes, that's the one that they have given a timeline. So we know, you know, this sort of in a couple of years' time, we will be working to this new regime.
mm,
So really, we will have next year to get ready, and hopefully the detail will come through. I think in terms of what people need to be thinking about, but for loads of businesses that I work with, the view seems to be, oh, basically everyone's got a 2 year probation period.
mm,
So even if the contract has a 3 month, 6 month, sometimes longer probationary periods, people tend to be very relaxed about it. Often people don't even bother to confirm the appointment. They may not have meetings. Obviously, it depends very much from organisation to organisation,
mm,
but often what we see is that people are approved, the probationary period is approved, but actually in a year's time, so maybe in 18 months after they've joined, we then get calls from clients saying, we need to get rid of X. And then you talk to them about it and they say, well, actually, they never really performed from day one, but we just approved them because we hope they might improve, or, et cetera, et cetera. And there was never really any proper performance management. So I think a key takeaway is we're going to have to really educate managers
Mm.
to make sure that they are properly managing their teams, and that we really do use this probationary period properly. And I think for a lot of organisations, not all, some are very good at this. This is going to be quite a mind shift.
Yeah,
So that's
I think one of
important.
the things you and I discussed the other day when we were having a chat is that, certainly from my perspective, and 20 odd years of being involved in this sort of stuff, is that too few companies are really properly geared up for what I think are really robust systems of
Yeah,
hiring and then onboarding.
yeah, yeah,
And the onboarding process now is not just about, giving them the right documentation, although that's really important, but it's about, as you say, almost setting up a system which is actually in the employee's interests as well. And I always think, employment matters are very much a two-way street. It isn't just about the employer being the big I am. It's also about
mm,
trying to create an environment that's really equitable. And if they've if you as an employer have set up really good processes in the first place in order to ensure that you're getting, and by the way, you should be doing this anyway from a discriminatory point of view, even under the current law, but if provided you've set up really good processes in your recruitment aspects
mm,
and your onboarding, then you're in a much, much better position, as you say, from a performance management point of view. If it's really clear to your new
mm,
employee what is expected of them, then even under the current rules, you're in a much better position and probably a much better position to actually improve performance as well. So this is where I think some of these things, although it's all kind of as an employer, we kind of all think, oh gosh, this is going to be a real problem for us. In actual fact, it might present an opportunity to say, let's make our HR systems much, much better than they currently are. And I think there's an opportunity
yeah.
um, for a lot of people. It was a great statement I heard from a friend of mine the other day who does presentation skills, which we sell out to our clients. And he said, how I position myself is I can make your presentation skills 10% better, however good you are. Now, I would say that whoever you are and whatever HR processes you've got in place, if you have those properly assessed, you can make them at least 10% better than they currently are. And you're going to
Mm,
need to. That would be, I don't want that to sound too opportunistic, but that is really an
mm,
opportunity, I think, for companies to radically improve
mm,
their recruitment, onboarding, and just their general management. I mean, how many people, who are listening to this, if they've got, teams and hire people, how many of them have ever had any training on how to hire?
mm,
How many have actually got a really robust system on how to onboard and then to monitor those new people in terms of their performance and so on? So these are the sort of things I think, then we obviously don't want to reduce the amount of work that Helen gets, but I mean, in a way, that would be, from the disciplinary point of view, then this is the
mm.
reason often why these situations arise, and you then get brought in to sort it out, is because probably, I mean, would you agree with that? Is it often
I
when you
would,
see, yeah,
yeah. And actually, one of the things we've also been talking about with clients is that the whole way that you advertise positions as well, because I think often adverts either sort of undersell or oversell the job,
hmm
and there's a bit of a disconnect between, often one of the key reasons why people don't perform is because they thought they were coming in to do X, and actually what the business wants is either X plus or X
it's a
less.
great point. Yeah,
Um,
absolutely.
and I see that a lot. And then, the employee feels quite disgruntled. They probably
Mm,
moved from a job when they were happy in, maybe for a pay rise, but
mm.
that isn't most people. Money is obviously important, but what they want is that career satisfaction as well. And then that immediately sets up sort of a problem, which will
It's a
then play out into.
mismatch of expectations, isn't
Exactly,
it?
and
Yeah.
then that sort of mismatch or butting of heads will result in a potential claim, because
Mm.
although yes, I suppose there is a lot of discussion about will tribunals increase, and I think there probably will be, but I always feel that actually with the clients and the businesses that I work with, I would much rather be doing sort of more positive projects with them, as you were talking about, Nigel,
Mm,
than actually litigation. It's normally a sign that something's gone wrong
mm,
somewhere. And really, it's not necessarily the sort of work that we want to be doing, although
mm.
sadly we do, and we do work with a lot of businesses who do get into problems.
I mean, that's the sad reality, isn't it? However good your processes
Mm.
are, you do need to accept and understand that sometimes it will, for all the best reasons,
Yeah,
sometimes there is a lack of alignment between a new hire
yeah.
and so on. Now, which kind of segues sort of nicely into flexible working.
Mm.
I'm a big proponent of flexible working. I think it's something which the genie is out of the bottle, and for those employers who desperately want to put the genie back in the bottle, I think they're fighting what could be a losing battle, and in fact also could potentially put them at a severe disadvantage in terms of the kind of competition for talent. But what are the changing situation, or is there a change really to flexible working, and what should employers be thinking about in terms of that?
Well, I think the current position is, and actually this was introduced by the Conservatives in April, is that now from day one, anyone can make a request for flexible
Mm,
working. And they have sort of two bites of the cherry in any year, which was never the position previously. And the employer is required to sort of obviously go through the process, consider that whether there's a legal reason for refusing the request. And the
mm,
position is that there are 8 sort of legally fair reasons for refusing. So you don't have to accept it if it doesn't work. And one that's often cited is, it's going to cost too much, or it's
mm,
just going to impact on productivity, etc., etc. But you have to shoehorn your decision making into that and follow the process. There is a proper process that's set out in the statutory regime. What the government is suggesting is that basically the test should be that they'll still keep those legal grounds, but as employers, we have to show that it's reasonable to refuse. So it's not just within the ground. So it's not just that a ground's made out, but that it's reasonable.
Can you
Um,
think of any sort of examples of I'm thinking maybe about our audience today in terms of life sciences. Can you think of any sort of examples where it would be reasonable
well,
to
I mean, I think
refuse?
I think an obvious example, and sometimes it does come up, is with your lab staff. If you've got lab staff, occasionally we've had a few, especially around sort of coming out of COVID. um, there was a lot of lab staff was sort of asking very much. They wanted to, is there a way we could do more? Could we perhaps do duties at home? Could we, work in a slightly different way? And obviously that's just never going to be reasonable because you need your
Mm,
lab staff in the lab. You might be able to do some sort of paperwork or reporting or that kind of stuff from home, but that would be absolutely reasonable, and I think you would shoehorn it into, the fact that you just can't. One of the legally fair reasons would definitely be made out there, but you could also go on to quite easily show it was reasonable to refuse. So that would be an example there. But there's lots of, I mean, it's really, I think, comes down to, again, I think building on the points that you were raising earlier, Nigel, it's about sort of having that dialogue with your employees. So I think,
mm,
see, often when the flexible working requests go wrong and you end up with a claim after them or resulting from them, it's where people feel that they haven't been heard, the process hasn't been followed properly, and their request has just been disregarded. So I think so long as you follow the fair process, give a fair justification, um, it should be possible if you think it's the right thing to do to legally refuse. And but I do feel that, going back to that point about reasonableness, some of the commentary that the Labour government has put out about flexible working isn't that helpful for business, because there's been a lot of, the press headlines are Labour government says that flexible working should be the default. And that isn't actually what the legislation says, and that isn't going to work for many of us working in life sciences, just because of the nature of the roles that people have
Mm.
and the type of work that they're doing, sadly.
And I suppose, unfortunately, those sort of headlines get out there, and then that gives an employee
Mm.
an unrealistic expectation.
Exactly.
And I suppose the sort of end jeopardy point for the employer there is being taken to a tribunal, I suppose, if somebody is refused. But I guess also the other potential challenges is a demotivated individual if they don't
Mm.
feel they've been listened to properly. And then we go back to the
Yeah.
same issues that we were talking about earlier, really.
Yeah.
So I guess it is, um, again, good management, really, that
Exactly.
is perhaps the way to best mitigate any challenges that come from it, and make sure that people are being listened to and feel that they're being listened to is uh, is important. So I suppose that any other risks that you can think of if people fail to meet that trend, I mean, what would be the other?
Well, I think
Are there any other legal risks, shall we say?
yeah, I mean, from a legal perspective, the risk is obviously if you have, and we have got sadly a few clients who are in this position at the moment. There is a claim. Anyone can bring a freestanding claim. You don't have to resign or anything. You can actually bring
Mm,
it while you're employed for compensation, and it's up to 8 weeks' pay. So it's not a
right.
huge amount of money,
Mm,
but it's capped at the moment at £5,600. So
mm,
that, which is, and for one, we have a number of clients, and it'd be interesting to see if anyone in the audience is going through this, where the music seems to be changing, and a lot of people are coming to us saying, actually, we want everyone back at work
mm,
physically in the office 5 days a week.
mm,
And what I would say to that is obviously that's a you need to think very carefully if you're thinking about that, about your getting your PR and your comms right, because that's going to, it potentially will alienate some staff. But the
mm,
second impact of that is expect a torrent of flexible working requests, because
mm,
that's certainly what we've been dealing with a few clients that have introduced that policy. And they would say, well, they've got very strong business reasons for wanting to do that. So, and they feel that that's the right thing for their business, but you do need to manage that very
mm.
quite carefully, I
I think
think.
there's another which you kind of touched on there, but a really important element, I think, for all of you that are watching or listening. You're in a market where the talent that you need is in short supply. It's what in recruitment terms we would call um, it's a it's an employee driven market, if you like,
Yeah.
or candidate driven market. So you've got to think about what message, as you've just referred to, really,
Mm.
there, Helen. It's what message is that policy sending out, and it is a big message because it also it's actually quite a complex, sometimes mainly negative message, and it says
Mm.
we want to tell you what you have to do. But secondly, flexible working has all sorts of connotations for equality as well, because
Mm.
um, for whatever societal reasons, it's generally more likely that people with younger families will want that, whether they're male or female, will want that level of flexibility. So you also have to actually think about what message it's sending to that as well. So I would think from an employer branding point of view, then employers really need to think very carefully about how they balance that discussion, because it should be a discussion, and but also thinking in terms of, if I'm going to emphasize more towards everybody must be in the place of work, then you're actually restricting yourself and cutting off probably a really, really good part of the workforce who would make great employees. That would be my
Mm.
message from that. Which is
Yeah.
alongside the legal aspects of this, is to actually think about the message that it potentially sends. Equally, I'm also sympathetic to those people, and as you say, Helen, like people who are working in labs. There is work where you just cannot might be able to do a little bit of paperwork or some research work at home, but for the most part, you've got to be there.
Yeah,
So
absolutely.
that's reasonable, isn't it? Oh, very good. We've also, I've had a number of people, understandably, a little concerned. Perhaps some people obviously will see it as a positive thing. Sort of point three of our discussion really is around collective union rights. Now, this is a
Mm,
big change, isn't it? And I think any of
mm.
those of you that are, directly or indirectly involved in HR, I think this is really interesting because a lot of HR professionals will have done their whole career with having to have nothing to do with trade unions, no negotiation with trade unions. Well, they're probably going to have to upskill at some point related to this. But can you maybe just sort of explain that piece
Yeah, I
from
mean,
how
I think
the legislation is changing?
there's a whole scale raft of changes that are coming in relation to the rights of unions, and very much in reality what the Labour government is proposing is to sort of rip up the current framework and replace it with a new, much more pro union framework. And as a starting point for that, which will impact on everyone, whether you recognise a union or not, you will be expected to include in everyone's contracts of employment details about their rights to join a trade union. So it's quite a fundamental change. And obviously, you can see exactly where that's coming from, which is to obviously give much more publicity and
Can I just
credibility to
interrupt you? Sorry
unions.
to interrupt you there, because that's
Mm,
actually a really interesting thought,
mm.
which I hadn't thought of before. Should people be, are they going to be required to rewrite all existing contracts to have that clause in there, or is that going to be so? So this is something this is an actionable thing which they need to actually look at, presumably.
Yes, they will do. Yeah. So
Yeah.
I mean, some of the depending on what you've got in your, so for example, a lot of clients don't have probationary periods in their
Mm,
contracts. So obviously they're going to wait and see, I think, in terms of how long the what period the government sets. They may go for a shorter one, but probably we're going to be, or people might want to increase their probationary period to 9 months if they've got a shorter, say, 3 6
yeah.
month period.
So that's
So
new. Sorry to interrupt again, but that's new. Yeah. So what I'm
a
talking
bit
about is
new.
existing, contracts. Should they
Yes.
reissue those with these new rights within them, or with the existing contract, even though it's not got that in there, would that be sufficient?
The for existing contracts, you will have to update existing contracts because what the government is going to do is they're going to under that's a bit of a boring technical one, but under
Mm,
there's a list of requirements that have to be included in everyone's employment contract, and what they're suggesting is that this right to join a trade union will become a mandatory term in everyone's contract. So whether you've worked for a business for 10 years, 15 years, or you're a new joiner, and the sanction if you don't include that list of section one, it's called the section one terms, there is a sort of a freestanding right to compensation. So if someone were to bring a claim to a tribunal, and your contracts weren't up to date from a legally compliant perspective, then the tribunal they was asked to look at the contracts, and they will award, if it's not compliant, an additional amount of compensation, um, which goes up each year. It's not a huge amount. I think at the moment it's about £800.
mm.
So it's not. It's but
So it's
it's
probably
just
unlikely, but nonetheless, this is good practice to know that you need
yeah,
to be, particularly when this
definitely.
new legislation comes in, that you do need
You
to
will have to.
update
Yes.
yeah. So
Yeah.
sorry, I did interrupt you on the union rights thing. So could you just talk us through a little bit more on what that actually means in practice for
So I think
employers?
obviously the first proposal is very much about just highlighting the fact that you can join a union. And I think the reason for that is because for so many people, maybe under 40, they've just not really been familiar with working in a unionized environment, or even
Mm,
really know what unions do or how they can help them.
mm,
In the private sector, obviously, the public sector is different,
mm,
generally, that is. But the second right, which I think a lot of is probably the one that's causing most of our clients the most angst, and we're getting the most queries about, is what's this new right to be able to access your workers. So this is completely new. It's not a
mm,
right at all. And what it means is that, in very simple terms, a listed union, and the government will let us know what that list is, but I'm assuming it'll be people like the GMB and all the large unions, will be able to make a written request to employers that will follow a prescribed format. That will be, we don't know what that looks like yet, but it will be
Mm.
just to set out in the legislation, which will allow them to basically be able to come in and access your workers. And that'll be to enable them to properly represent their workers, to recruit new staff, to organise their members, and also to start to implement collective bargaining, which is basically when you have an agreement with a recognised union around things like pay, hours of work, terms and conditions. Um, at the moment, if there's a union, if people are union members, there's no actual right for the union to come in and talk to their members actually in the workplace. So I think you can see it's quite
Mm.
a significant
I
change.
think particularly the collective bargaining piece, I mean, that kind of
Yeah,
sends shivers back to the 1970s, doesn't it?
yeah, exactly.
So,
So
so yeah, that is kind of, and I guess again for our audience, for those that have, particularly, and sorry to generalize, but like lab staff and so on, I could
mm,
imagine the unions will understandably see that, that type of workforce as being one that would be,
mm,
um, relatively appropriate, I think would be the phrase I'm trying to look for them to unionize. And so therefore, I think all of you that are listening, watching, need to be thinking about this in terms of this is potentially, and it isn't necessarily a completely bad thing for an employer.
no,
Again, comes down to being prepared for it, having your policies and procedures in place, and and looking to see how you can engage with a union, I guess. But it's certainly, I think it is an area of significant change, assuming it all comes to fruition, which of course a lot of these things are. Again, to reiterate, they're in consultative phase, but I guess the chances of that not coming in, I should think, is
I think
probably small.
I think so, because it was a manifesto, it's part of their
Yeah.
manifesto commitments. So I mean, I think the only point I would make is that I think there's certainly in some of our clients, some of their workforce have previously worked in, say, the NHS or
Mm,
um, depending on and so they are the workforce are potentially quite used to working in a unionized
mm,
environment. So I can see that there it would be quite easy for some of, say, like you say, for example, Unison or some of the more public sector focused work unions, rather, to potentially target some of the larger life sciences companies initially, and then maybe move into some of the
the
smaller
SMEs.
ones.
Yeah.
Um,
Yeah.
and I think it depends really how, if the workforce sees that there's a benefit,
Mm,
as to how successful that will be. Um,
mm,
which is sort of brings into the next change, which is that at the moment, you obviously unions can apply for trade union recognition, and there's quite a for any of you who've been through that process, I've sort of helped employ a couple of corporates, well, more than that actually, to successfully avoid being an application, because there are lots of things you can do to avoid it. But the at the moment, the actual various sort of triggers for being able to apply for trade union recognition are quite high,
hmm
and the test is quite a high bar. The plan is that that process will be much more simple, and of course the bar will be lower. So
mm,
again, if you've got people that are members of a union, and you've got a group in a particular area of your workforce, they may well apply for trade union recognition. And then once they've got that application for trade union recognition in, then the members will be able to, the union representatives rather, will be able to come in potentially under one of these access agreements, which is a new thing, and they will then be able to recruit potentially other members from your workforce. So I think that's the plan, and that's how things potentially will shape out.
Yeah,
So it's quite
and
interesting.
I do think and that it's an example of being prepared, which I keep saying, but
Yeah.
also just making sure you've got the right advice from people who understand the mechanisms and know how to negotiate as well. And it's a completely different skill for those people who have not been involved in it
Mm.
before. It is a different skill. Um, Unions are, of course, very different from, or at least we hope they are, from they were in the 70s. So it is a potential, as it is in many other European countries, there's potential there for collaboration and perhaps positive outcomes. But it's also understandable that it is a concern. So, but sort of
I mean,
moving on to the last point that we wanted to cover, and I think this one's a really important and I think really positive change, which is around the duty to prevent sexual harassment. Well, one would have thought that an employer has that anyway, but what's the sort of legal change there? How is that different now? So how is it proposed to be different from where it is today?
yeah. So the this change is actually now it's in force. It came in at the
Mm,
end of October, and the new under the new regime there is this sort of positive duty to prevent sexual harassment taking place, whereas and it's really sort of a result of the Me Too campaign and
mm,
the various campaigns that have been since that happened just before lockdown, sort of 2018. The difference is that employers will have to show, so if there's a complaint made that goes through to a tribunal of say sexual harassment in the workplace, and that claim succeeds, as part two of the claim, the employer will then be sort of put on the spotlight to say, well, what could you have done? What steps could you have taken to prevent this from happening?
mm,
And if you can't show that, so if you can't establish that you did take steps to prevent sexual harassment happening in the workplace, then any amount of compensation that the lady or man who's been harassed would claim will be increased by up to 25%.
right.
And harassment, any discrimination claims, as I know you'll all know, are unlimited. They're
Mm,
uncapped. So you don't have the cap, which obviously applies to unfair dismissal. So it could be quite a significant uplift depending on the amount of compensation that the person's in line to receive. So that then sort of obviously the next big question on everyone's lips is, well, what can we do? How can we show that we've taken reasonable steps to stop this happening? Because the obvious point that everyone makes is, well, at the end of the day, I can't physically control. HR team are not going to be present in
mm,
every discussion, every your manager. We can't physically be micromanaging our staff to that extent. So there's some obvious things that you can do, and there's been a lot of discussion about training. We've been doing quite a lot of training to senior managers, reminding them of their obligations and what they need to think about. But the really good advice, I think, is to think about, if you haven't done it already, do make sure you've got a risk assessment.
mm,
And the EHRC has published, if you haven't seen it, they've published a really useful document which gives employers guidance on what to think about when you're putting together that risk assessment. But the where we've been advising people on completing a risk assessment, and what we say is, well, the best starting point is to think about auditing your workforce. Think about, have you had claims? Have you had, even if they've not gone to tribunal, have you had grievances about inappropriate behaviour in the workplace? What's the cause of that? Is there anything
mm,
we can do as a business to maybe prevent that happening? So An obvious area where there's a lot of discussion about it at the moment is the Christmas party. Do you allow people alcohol at the party? If so, do you limit it? A lot of people are saying, well, we're going to have an open bar, but people can only drink wine and beer, but can't drink shots or spirits. Um, I've got a couple of clients who said it's just too difficult. We're not even going to do a Christmas party anymore, which I
Well,
think is really
I know
sad.
at least one employer that in fact has actually taken that
Yeah.
after various bad behaviours. I mean, I guess one of the things around this is also, I guess, your duty of care as an employer to all your employees and
Mm.
ensuring that you mentioned grievances there, Helen. I guess one of the things would be what happens when you have got what's your process when you have when a grievance takes place? Have you acted on it? Have you ensured that that person knows that they can express a grievance? So it's about facilitating an environment which enables that. Um, Policies obviously
Mm.
again, and then what is the follow through? So I think also I mean, cases in the BBC at the moment are pretty shocking, without, judging individuals, but I mean, in
Yes.
terms of it's shocking that anything like that happened without any apparent follow up. That's what it appears anyway, and obviously
Mm.
that's just based upon media reports, but it's if you have a report of something happened, you've obviously got to give the accused the benefit of the doubt as well. But at the same time, you need to be seen to be doing something,
Mm.
and making people aware that they have that ability to complain, and then it's seen that you do something following on from that. And I think if it went to a tribunal and it was demonstrated that you generally had a kind of, whatever type of approach to this, then I think
Yeah.
that would be a problem, wouldn't it?
Yeah.
Oh, it's
No,
very good.
definitely.
So we've covered a lot in ooh, just over three-quarters of an hour. Is there any kind of closing thoughts or anything you've got, Helen, in terms of, what with all of these areas, general advice you'd give? I would say, don't be reliant on this advice, as we said at the beginning, but just sort of general advice for people relating to these changes or thoughts.
Yeah. I mean, I think there's just one point that I wanted just to sort of stress about arising from the day one change to unfair dismissal. And that is that the ability that so the position is that the 9 month sort of statutory probation period will, we think, only apply to dismissals for poor performance.
Right.
So if you are thinking about, say, dismissing someone for redundancy, which can sadly happen, you might maybe lose some funding or quicker than you'd thought, or
Mm,
and you've just taken on some staff and you think actually we don't need them anymore, or you might be wanting to diversify into a new product or um, something. Hopefully that won't happen with your new joiners, but it does sometimes happen.
mm.
Um, we think we're waiting to obviously get the final draft, but for those people, you will still have to go through. They will be able to claim unfair dismissal from day one. So it only will give you that sort of 9 month protection for sort of scenarios where you're in that probationary period. At least that's our
Quite
understanding as
interesting, isn't it? I
drafted.
mean, obviously, I'm sure most people will know this in the sense that you make a position redundant rather than an individual,
Yeah.
don't you? And there has to be justification for that, and there is a sort of statutory definition, isn't there, of redundancy
Mm.
as such.
Yes.
So, but yeah, I mean, I think the watchword for all of this is being prepared, understanding that the employment regime, whether one likes it or not, there's no point railing against change. It is happening.
Yeah.
We have to understand that as employers, we've all got to get, we can manage at least 10% improvement on most things that we do. So
Yeah.
there are definitely big areas. So Helen, thank you so much. Really, really interesting. I've learnt loads talking to you, and I hope everyone else has. I don't know whether we've got time for any questions. I don't know whether any questions have come through as such. If anybody thinks of questions that they want to send through, I know that Lorna, who is recording this, has got a screen in front of her for questions if you want to have some questions. Obviously, if you want something in more detail, then speak to your advisors, whether that's us on the broader HR point of view or from a legal perspective with respect to Taylor Wessing. I'm sure we'd all be delighted to engage with you. Equally, do get advice if you've got existing advisors. Get advice on this stuff. I think there are lots of reasons to be really engage with this and get the most out of it, but also mitigate against the what could be pretty serious consequences if it's ignored. So hope you all found that really useful. Is there anything else you want to say just to wrap up, Helen, before we go?
No, just thanks so much to everyone for participating. It's been I've really enjoyed chatting this through with you, Nigel. And I just really echo what you said, which is I think it's all about being prepared. We will get a lot more detail and we'll be able to come back and give you more information as the legislation progresses. Um, so it'll be good to reconnect and debate and discuss some of these ideas when we've got a bit more certainty in terms of the detail.
Good. And of those of you that are BIVDA members that are still with us, please, if you've enjoyed this and found this useful, can you please inform your colleagues and friends to attend the next ones, because we're going to do a series of these as and when. It's been great to have Helen with us, and I'm hopeful Helen hasn't been too awful an experience, so that you will be wanting to come back
No,
and
it's
give
been
us your
great.
wisdom again in the future. So
Thank
thank you
you.
very much.
Thanks. Thanks, everyone.